this grand juror reached out to an attorney last Friday, just 2 days after Daniel Cameron made an announcement on the Breonna Taylor decision. He's requesting declaration of rights so he can speak freely about the case because he believes the public should know the truth.
My client has an issue with the levels of accountability and disclosures that have happened to this point.
The truth, the whole truth, and nothing but the truth. Attorney Kevin Glogauer says the anonymous grand juror wants everyone to know what happened over the course of 2.5 days before the decision came down.
Are we limited to the only things that are recorded? Or can we talk about the things that weren't recorded?
Cameron's office says it will comply with Judge Ann Bailey Smith's order to release the recordings for the discovery process in Brett Hankinson's case.
Generally speaking, in the Commonwealth of Kentucky, the grand jury proceeding only records the opening statement of sorts of what it's about. A witness is then called and sworn. They give limited testimony, very short in general, and at that point, they go off the record.
The Attorney General's office said prosecutors presented all of the evidence, though it supported that Sergeant John Mattingly and Detective Cosgrove were justified in their use of force, saying in part, quote, "For that reason, the only charge recommended was wanton endangerment."
What was actually presented to them, if anything? What were those charges? Who were the defendants or potential defendants? And then what was the recommendation, if any?
Attorney Glogauer claims that the set of grand jurors heard several cases before Breonna Taylor's. None of them, he says, lasted more than 1 day. He couldn't reveal the racial and demographic makeup of the grand jury.
Probably appears underrepresented by minorities, but that's something that perhaps becomes a part of the bigger discussion, because that's not atypical in Kentucky.
If a judge approves the grand juror's request, he and his attorney will explore the different options to freely share his side of the story.
Now, the Kentucky Attorney General is seeking a 1-week delay in the release of Breonna Taylor's grand jury recordings. The Attorney General's office filed a motion asking the courts for that extension, saying the delay is needed to protect the personal identification of witnesses involved in the proceeding.
Motion for release of grand jury transcripts, recordings, reports, and for declaration of rights pursuant to KRS 418.040. Comes the plaintiff, grand juror, by counsel and moves this honorable court to release any and all recordings of the grand jury pertaining to what is commonly known as the Breonna Taylor case that resulted in indictment number 20 CR 1473, styled Commonwealth versus Brett Hankinson, pursuant to RCR 5.24. Grand juror further petitions this court for declaration of rights pursuant to KRS 418.040. Specifically, grand juror seeks the court to make a binding declaration that grand juror and any additional members of this grand jury has the right to disclose information and details about the process in the grand jury proceedings held in Jefferson County, Kentucky, regarding the above case known as the Breonna Taylor case and any potential charges presented or not related to events surrounding the matter. In support of this motion, grand juror states the following. Number 1, grand juror was a member of the grand jury for the month of September 20th in Jefferson County, Kentucky. Supporting documents attached. Number 2, beginning on or about September 21st and until September 23rd, 2020, grand juror and the other grand jurors were tasked with being the grand jury for the presentation by the Office of the Attorney General, purportedly all matters related to the death of Miss Breonna Taylor after a Louisville Metro Police Department raid of her apartment. Number 3, subsequent to the above referenced indictment, Attorney General Daniel Cameron held a press conference to publicly announce the charges against Mr. Hankinson and to further announce that there would be no charges against Sergeant John Mattingly and Detective Miles Cosgrove. Number 4, Attorney General Cameron made many definitive remarks during his press conference. Among them, he stated that his office's investigation found, quote, and the grand jury agreed that Mattingly and Cosgrove were justified in the return of deadly fire after having been fired upon by Kenneth Walker, close quote. Number 5, when questioned about whether he made a recommendation to the grand jury, Attorney General Cameron stated that grand jury proceedings are secret, and so I'm not going to get into the specifics about the details of that proceeding. What I will say is that I presented all the information, and they ultimately made a determination about whether to charge. In this instance, they decided to indict Detective Hankinson, close quote. Number 6, Upon inquiry regarding approximately a dozen witnesses stating that they did not hear the police knock and announce, and the Attorney General relying on one witness to the contrary, Attorney General Cameron stated in part that he thought the, quote, more pertinent question is what was the evidence provided to the grand jury? What was sufficient for their purposes? They got to hear and listen to all of the testimony and made the determination that Detective Hankinson was the one that needed to be indicted, knowing all of the relative points that you made. Close quote. When asked if the grand jury considered manslaughter, reckless homicide, or those kinds of charges, Attorney General Cameron stated the following. I won't get into the specifics again of the proceedings themselves, are secret, but what I will say is that our team walked them through every homicide offense and also presented all of the information that was available to the grand jury. And then the grand jury was ultimately the one that made the decision about indicting Detective Hankinson for wanton endangerment. Number 8, the secrecy of grand jury proceedings and their potential disclosures are controlled by RCR 5.241, which states as follows. Subject to the right of a person indicted to procure a transcript of recordings as provided by Rule 5.163, and subject to the authority of the court at any time to direct otherwise, all persons present during any part of the proceeding of a grand jury shall keep its proceedings and the testimony given before it secret, except that counsel may divulge such information as may be necessary in preparing the case for trial or other disposition. Number 9, the Court of Appeals of Kentucky stated plainly and clearly that only the court itself may order the release of grand jury proceedings, to which the Office of the Attorney General found and actually agreed an opinion of the Attorney General 95-17 issued on May 10th, 1995. Quote, a grand jury is part of the court and under judicial control, so there can be no doubt that a session of the grand jury is proceeding in a circuit court. Greenwell versus Commonwealth, Kentucky, 317 SW, 2nd, 859-861, 1958. The opinion of the Attorney General further pointed to Ex parte Farley, Kentucky, 570 SW, 2nd, 617, 1978, and York versus Commonwealth, Kentucky, App 815 S.W. 2nd, 415, 1991, further agreeing that the judiciary has exclusive custody and control of grand jury testimony and proceedings as a court record. Number 10, there can similarly be no doubt that this court had and has the exclusive custody and control of the grand jury proceedings in question, as the grand jury reported to this court for the month of September 2020, and reported the very proceedings in question, at least in part, to this court. Number 11, the Attorney General publicly made many statements that reference what the grand jury heard and decisions that were made based on what certain witnesses said. He further laid those decisions at the feet of the grand jury while failing to answer specific questions regarding the charges presented. Attorney General Cameron attempted to make it very clear that the grand jury alone made the decisions on who and what to charge based solely on the evidence presented to them. The only exception to the responsibility he foisted upon the grand jurors was his statement that they, quote-unquote, agreed with his team's investigation that Mattingly and Cosgrove were justified in their actions. Number 12, there is a compelling public interest for these proceedings to be released of a magnitude the city and Commonwealth have never seen before that could not be confined, weaving its way across the country. The citizens of this Commonwealth have demonstrated their lack of faith in the process and proceedings in this matter and the justice system itself, using the grand jurors as a shield to deflect accountability and responsibility for these decisions only sows more seeds of doubt in the process while leaving a cold chill down the spines of future grand jurors. Number 13, the public interest spreads across the entire Commonwealth when the highest law enforcement official fails to answer questions, but instead refers to the grand jury making the decisions. The interest of the individual grand jurors is parallel to the public, but also manifests as fears of persecution, condemnation, retribution, and torment. Unfortunately, they do not get to hide behind the entity, person, or office. Number 14, the handbook that grand jurors were given in Jefferson County, Kentucky, at the beginning of their service encourages them to, quote, to share, without divulging the content of any grand jury hearings, your experiences in the criminal justice system with your family, friends, and neighbors, close quote. See attached. It would seem that from that statement, that at least the Jefferson County Office of the Commonwealth's Attorney intends for their experience to be one that should be used to promote the education and future participation of the public. It certainly seems to suggest that grand jurors are free to discuss their participation in the grand jury process, even if they are to keep secret the content of the hearings. This highly likely includes informing their family, friends, neighbors, and employers of their participation as grand jurors. The level of attention this matter has received across the country creates an inability to calculate how far these seemingly innocuous disclosures of their participation have reached. It is precisely for these reasons that the grand jurors wish to remain anonymous while feeling compelled to act in a manner that promotes transparency, truth, and justice without further sacrificing anyone's right to feel comfortable in their own mind and body for their compulsory grand jury participation. The decisions that were alleged to be exclusively theirs by Attorney General Daniel Cameron. Number 15. It is patently unjust for the jurors to be subjected to the level of accountability the Attorney General campaigned for simply because they received a summons to serve their community at a time that adherence to the summons forced them to be involved in a matter that has caused such a palpable divide between sides. Number 16. Truth being of paramount importance to all affected parties and the community as a whole, justice demands a full public release of the grand jury proceedings. Not only are the grand jury proceedings the sole province of the court, but there is, quote, an inherent power in the inescapable duty of the trial court to lift the lid of secrecy on the grand jury proceedings in aid of the search of truth, close quote. Dennis versus United States, 384 U.S. 855, 868, 1966. For the reasons stated above, and in the interest of justice being applied equally and appropriately to all interested parties, regardless of their race, position, or association, Grand Juror respectfully asks that this court exercise its power pursuant to RCR 5.241 and order the release of all recordings, transcripts, and reports of the grand jury related to this matter to the public. Declaration of Rights pursuant to KRS 418.040. Number 18. Grand Juror further seeks for the court to make a binding declaration that Grand Juror has the right to disclose information and details about the process and details of the grand jury proceedings held in Jefferson County, Kentucky regarding the Breonna Taylor case and any potential charges and defendants presented or not presented related to the events surrounding that matter. Grand Juror asserts that RCR 5.241 only governs what was recorded during the proceedings held by the grand jury, and therefore any details surrounding the actions outside of those recorded proceedings and anything that did not happen in the grand jury proceedings are permitted to be disclosed. The penalty of contempt as detailed in RCR 5.243 shall not comply to any such disclosure, nor should any other civil or criminal penalty. Number 19. A petition for declaratory judgment pursuant to KRS 418.040 provides for the venue and cause of action, providing as follows. In any action in a court of record of this Commonwealth having general jurisdiction wherein it is made to appear that an actual controversy exists, the plaintiff may ask for a declaration of rights either alone or with other relief, and the court may make a binding declaration of rights whether or not consequential relief is or could be asked. In order for a state to claim a KRS 4.18.040, a petition must show that an actual controversy exists. Foley v. Commonwealth, 306 S.W. 3rd, 2831, Kentucky, 2010. Quote, an actual controversy for purposes of declaratory judgment statute requires a controversy over present rights, duties, and liabilities. It does not involve a question which is merely hypothetical or an answer which is no more than an advisory opinion. Barnett versus Reynolds, 817 S.W. 2nd, 439, 441, Kentucky, 1991. Citing Dravo v. Liberty National Bank and Trust Co., 267 S.W. 2nd, 95, Kentucky, 1954. Number 20. Grand Juror states that there is an actual controversy over their own rights, duties, and liabilities as a grand juror and as a citizen of both the Commonwealth of Kentucky and the United States of America. Grand juror states that RCR 5.241 does not apply to anything that was not recorded as part of the grand jury proceedings, and that they are well within the bounds of permissible disclosures to the public when those disclosures pertain to details that inform tangent to but not part of the recorded grand jury proceedings. Similarly, the rule does not prohibit disclosing things that did not happen during the proceedings. Specifically, the rule does not resist discussion of charges that were not presented to the grand jury. Explanations of the law that were not provided to the grand jury, defense, or justifications that were not detailed during the proceedings, witnesses that did not testify, potential defendants that were not presented, and/or individuals or officials who were not present for the proceeding. Number 21, this request is for declaratory relief from a fear of prosecution for disclosing information that was not part of the grand jury proceedings, and for a finding that it is permissible by law and not subject to civil or criminal liability to disclose. Number 22, as stated above, the Breonna Taylor case is a matter of great public interest that has been subject to much national scrutiny. Attorney General Cameron stated publicly in his press conference that no details would be discussed regarding the proceedings because they are secret. He then, however, disclosed information that acknowledged publicly other information that was part of at least the investigation. The multiple mentions of the proceedings being secret and Attorney General Cameron's efforts and desires for it to remain so create the controversy addressed in this action. It is the fear of the petitioner that Attorney General Cameron would attempt to utilize the court's contempt power under RCR 5.243 if there was a public disclosure that contradicted certain things that he stated happened during the proceedings, characterized the singularity of the decisions in a different light, or raised doubts about charges presented during the proceedings. Number 23, the same concerns argued above in favor of releasing the grand jury proceedings to the public are incorporated herein and further asserted that the need for a declaration of rights is to quell the fears of persecution, condemnation, retribution, and torment, along with the fear of prosecution that apply not only to the grand juror, but quite possibly to other grand jurors in this matter. Number 24, the full story and absolute truth of how this matter was handled from beginning to end is now an issue of great public interest and has become a large part of the discussion of public trust throughout the country. The legal system has placed the grand jurors in this matter on an island where they are left to wonder if anyone who finds them will treat them well or hold the pain and anger of the lingering question against them. Their choices are to remain there, hoping they are never found, or attempt to find a way to a safer position. That position is the ability to disclose everything the law provides to the public so that the truth may prevail. It should be noted that, as mentioned in the motion to discuss the recordings, the action is filed anonymously, not only for the protection, but also because there is no desire for notoriety or acclaim, only truth. This action does not seek any monetary damages, and there are no other actions pending that seek them either. Only the truth, the whole truth, and nothing but the truth. Number 25, Attorney General Cameron further stated in a press release in a response to a news conference held by the legal teams for Miss Breonna Taylor's family, quote, "Everyone is entitled to their opinion, but prosecutors and grand jury members are bound by the facts and by the law. This illustrates his position in the conflict raised in this action. The Attorney General has stated in an official press release his anticipation of grand jury members' desires to talk about what did not happen during the proceedings by mentioning them when there was no need to do so in his response. Attorney General Cameron's last remarks in his press conference following the indictment were as follows: "And I will fight for those across our state who feel like their voice isn't heard, who feel marginalized, judged, and powerless to bring about change. In a world that is forcing many of us to pick a side, I choose the side of justice. I choose the side of truth. I choose a path that moves the Commonwealth forward and toward healing. You have that choice as well. Let's make it together." Public speakers like to end on a powerful note, and the Attorney General did exactly that. He chose wisely in his speech. Now he has another choice in his response. Choose truth. Choose justice. Together, Kentucky. Then you have the wherefore clause, and then you have the judges this was sent out to. And last but not least, It was written by Mr. Kevin M. Glogauer, Esquire, the attorney for grand juror, located in Kentucky. I guess that will be our next legal bio attorney spotlight. Very interesting stuff.